Hi, Ray Dickey from Association Help Now. Thank you so much for joining us here with Cynthia. Today, we're going to talk about stinky, smelly neighbors and residents. We obviously know it's a problem in our industry. Cynthia, thank you so much for being here. And before we get started, could you introduce yourself?
Sure, thanks for having me. I'm Cynthia Jones. I'm an attorney with Sellers, Ayers, Dortch, and Lyons in Charlotte, North Carolina, and I practice community association law throughout North and South Carolina.
So what we're going to do today is, if it's all right with you, Cynthia, we're going to break it into categories. And the categories that I came up with were cigarettes, hoarding in unsanitary conditions, marijuana smoke, food, and body odor. And I actually did a poll beforehand. And Cynthia, do you want to take a guess which was the item that managers had to deal with the most? What was the item that they got the most complaints about?
Let's see. I would say probably food.
It was actually cigarettes.
What?
Cigarettes was 60%.
Oh, wow.
Of the complaints that managers receive. Hoarding and unsanitary conditions, which I was surprised, and we'll talk about it, was 17%. Marijuana, 11%. Food was 6%. And body odor was also 6%. I also did receive a note from someone that told me I should have included pet smells, because
I've dealt with the pet smells and the poop in the backyard and the neighbor being unhappy. So yes, I have seen that one.
I got an email and the board member said, pet smells are not on the list. Some homeowners use the space in their closets for litter boxes, and the smell goes into the other unit. So for future programming, I will have to add pet smells.
Yes.
So, all right, so let's get started with cigarette smoke. So secondhand smoke complaints are becoming more and more common. Let's start with the outside situation, if you don't mind, Cynthia. Someone's smoking on a balcony or a patio, and the smoke is irritating or bothering another resident. Where are we with that?
So it's interesting. There can be a couple different scenarios in that, but I'm gonna jump to the immediate one that I think of as I stare out at the Charlotte skyline and high-rise condos. Most of them have balconies, and a lot of the people will step out on their patio and smoke, and obviously the neighbors can smell that and it might disturb them. So in certain areas like that, those in condominiums are called limited common elements typically, if only the owner can use the patio. Some of the associations certainly can make rules about what owners can and can't do in those areas. You just have to look to their governing documents to see if they have the ability to stop something like that.
So I don't want to get off track on another topic, but a lot of people do ask, what is a limited common element? Can you explain to people what some of the differences are?
Sure. So a short and sweet answer to that is usually a limited common element is something that the owner has exclusive use and control over, like a patio that only they can access. But there is a possibility of having a limited common element shared between more than one owner. Maybe an owner and a neighbor have exclusive use of a patio, but it's basically an area that not all of the members have access to.
So a big question of the day, or one of them, there's going to be quite a few, is can an association board adopt a rule banning smoking in the common areas? And then I'm also going to ask you to say, can they do the same thing for common limited?
Okay, so let's deal with common areas first. Common areas are something like I would think of the main lobby of the condominium, or maybe the pool if they have a pool. The associations in North Carolina do have the authority under the Condominium Act to make and adopt rules and regulations concerning the use of the common areas. So yes, I would say that that is an area where the board would have authority to make a rule prohibiting smoking.
How about the patios and the balconies that are considered common? It's common limited, right? Element?
Yeah, close. Limited common element. But yeah, so you kind of treat those more like you do a unit itself. So typically, although the statute doesn't give you specific authority or give the board specific authority to make specific rules about members' use of their units and limited common elements, the declaration can give the board the authority to do that. So really, you just look towards those governing documents to see what authority the board has to make rules.
I don't know why this comes up a lot, but it does. Can HOAs ban smoking in yards?
Like a single family home, if it bothers a neighbor. So again, in a single family home, you own the lot itself, which really will be the house and the yard. In a townhome community, you're in the same kind of situation. You own part of the actual land itself. So in terms of that, again, the Planned Community Act applies in North Carolina. The association, while they would have the authority to make rules about common areas, doesn't always automatically have the authority to make rules for members' use of their lots unless their declaration specifically allows them to. So again, it's my lovely answer of you got to go to the governing documents to see what they say.
So what is the process involved if a resident or an owner's actions, let's start off with they're violating the restriction on no smoking? What would that process be? They're not allowed to smoke and they're smoking.
Okay, yeah, so absolutely. So we'll assume, for example, that they have a rule or some sort of requirement in their declaration that says no smoking, but you find out that they are. What do you do? Well, in North Carolina, you treat them just like you would any other owner who's violating provisions of the governing documents. And we have the ability in North Carolina to call the owner to a hearing, to institute fines against them, and to even possibly remove some of their privileges like pool access if necessary.
So this is another tough one. An owner, a resident is smoking in their unit and it is disturbing an adjacent or anyone else, as a matter of fact, from outside their unit. When do we determine that something becomes a nuisance, and is that the right word? Set us in the right direction here.
Yeah, so absolutely. So a lot of the governing documents that you'll see in North Carolina have provisions that an owner can't do anything which causes a nuisance to anyone else in the community. And it's a frequent issue. A lot of associations like to hone in on that provision when they have an owner complain about something like that. Unfortunately, the courts in North Carolina are very reluctant to enforce any of those provisions, and they have in fact said that they will not enforce a general nuisance provision just because they believe it's too vague. So the courts in North Carolina typically tend to strike those provisions if that's the only thing you're using as an enforcement. You could also have a specific provision on no smoking, and then you wouldn't have to rely on that nuisance provision. But typically, a nuisance provision is not going to be enough to have you hold an owner in violation.
So, to be clear, what does an association have an obligation to interject themselves in a situation where one unit owner smoking is causing a nuisance to another owner?
Yeah, so that's a more difficult question, right? So there have been instances throughout the United States where an owner has come to the association and complained. Maybe they have some sort of medical condition where the smoke affects them a whole lot more. And so they've come to the association to try and get the association to help with the neighbor to resolve the issue. I'm thinking there was a recent case, I believe it was in Michigan, about that exact issue and whether the association had to step in and really what did they have to do? What kind of accommodation did they have to give to stop the smoke from going into the neighbor's unit? And the court did a great job of distinguishing between, you know, what goes too far. And really, when you're living in a condominium type community, the court was very lenient to say, you kind of buy into some of that. You're going to have some intrusions from your neighbor. That's communal living. So they let the association install an air filter and try and resolve the issue, but they didn't go so far as to say, you got to quit smoking.
So one statement I have here in my research, and tell me if it applies. Federal and state disability laws, HOAs must modify their rules, practices, or services when necessary to allow a person with a disability equal use and enjoyment of his and her premises. What does that mean to a board or a manager?
Well, so in terms, you most often see that in other situations, but we are starting to see that in terms of, smoking specifically, is if it bothers me because I have an underlying medical condition, does the association have to step in and stop my neighbor from smoking? And really, I think it's other than the one case I know of in Michigan, I don't know of any cases in North Carolina. I think it's certainly reasonable to have the association consider what other options are out there, like some sort of air purifier, or allowing the owner to modify their air unit to add some sort of purifier to stop the smell from coming in. But I don't think the courts would go so far as to say you have to stop the neighbor from smoking.
And some examples would be asthma, allergies, chemical sensitivities, and other respiratory conditions. That's some of the terminology that ends up in these complaints.
Yes, absolutely.
So here's a two big words, right? Reasonable modifications. So an HOA must permit a disabled person to make reasonable modifications to a unit. And you just mentioned quite a few of them: air filters, exhaust fans. And the HOA is not obligated to pay for them.
Right.
Can you explain two situations, or explain what is a scenario where an HOA can insist on a smoker to make modifications, or a situation where an HOA may have to pay to make modifications?
Well, so in the terms of a single family community or a townhome community, the association's not going to have authority to do anything on the owner's lot. That's their property. You can certainly ask the owner to install something, but quite frankly, I would probably handle that in asking the affected person to go ahead and install something in their ventilation system instead of having the smoker do it in theirs. In a condominium, that may be a little bit different. Sometimes the air systems are in the common elements in between the walls and are shared among various units. So the answer for a condominium might be very different, in that the association may have control over installing the system in a condo, whereas they wouldn't in a single family home.
Does it matter if the issue is just bothering one person compared to if it's bothering more, several people?
Well, I think that's a good thing for the association board when they're faced with these situations to consider. Definitely their responsibility is to all of the members. And if they find out something's happening that's affecting quite a few members versus just one, they might need to come up with an association remedy or talk to their attorney to try and come up with a remedy, because it's affecting more of the owners. If they find it's just affecting one person, it could just depend on those circumstances. But definitely, if they start hearing from a lot of their members that something's becoming an issue, that's something the board's going to want to pay some attention to.
And to be clear, a condominium or an association, they can or they cannot make an outright rule where smoking is just prohibited, period.
You're going to get my favorite answer. It depends. They may be able to make a rule if their documents allow them to make rules concerning what owners do in their lots or their units. However, the best way of dealing with something like this is not to make a rule, but to actually put to your members an amendment to your declaration to deal with the issue, and to have it as a hard and fast requirement in the declaration instead of just a rule and regulation that the board adopts.
So I did receive questions from boards and managers in advance. And one of them is, can we do a master deed amendment designating the association as a smoke-free environment? I think you just answered that, correct?
Yeah. Yes, as long as the members vote for it, you can do an amendment It needs to be really reasonable. So both states, North and South Carolina, tend to want the amendments to be reasonable, but certainly depending on the situation, I think that that could be argued.
We've covered a lot of these questions already, but one we did not is, can we require smoking? Can we require the person to have the window open? You'd be surprised at how many people contact us and just say, can we make a rule where you have to blow the smoke out the window?
Well, again, it may depend on whether or not they have the authority to make a rule like that. When I see things like that, my immediate question is, how are you going to enforce that? That one's going to be pretty hard to enforce.
And I guess the person who's next door to the window may be the next complainant.
That's right.
Great. Well, thank you so much. Was there anything that we didn't mention yet as far as cigarette smoke goes?
No, I think we pretty well covered it. It is a big issue. A lot of times the clients that I've seen be most effective in dealing with problems concerning cigarette smoke or smells do so with an amendment to their declaration. So if you're considering something like that, definitely you want to talk to your attorney about helping you draft something.
And I think the other takeaway, and correct me if I'm wrong, is that associations now need to be very careful if someone claims a disability, correct?
Definitely, yes. You don't, in the old days, I'll say in the old days, we used to say often that's a neighbor to neighbor issue and the association shouldn't become involved in that. And really, we don't have the ability to say that anymore. There are times where we just have to ask a whole lot more questions if someone's trying to claim either discrimination or a disability. So the days of us saying that's a neighbor to neighbor issue, unfortunately, are gone, and the association is going to have to get involved in a whole lot more.
Awesome, thank you. Let's talk about marijuana smoke. So my first question in North Carolina is, what is the status on marijuana?
Not allowed.
And under any circumstances, not
No.
medically either?
No.
So there's not really too much to go over here because you've already, does it matter if it's marijuana smoke? Does the role of the association or the actions of the association differ if it's marijuana smoke compared to cigarette smoke?
I don't think it really makes much of a difference. Now, in terms of marijuana, I mean, it's not permitted here, so there may be some responsibility in reporting that to the police department, but in terms of the association being able to restrict it, it shouldn't be happening anyway, and they should be dealing with it in the same way, except they might have to get law enforcement involved.
I really hate to put you on the spot and ask this question because it's a really hard question for lawyers. But if a board or manager is aware that someone is smoking marijuana, do they have an obligation to report it? Should they report it? Is it any of their business?
Well, look, I mean, it's just like anything else. If I see illegal activity going on, what's my duty to report it? I tend to think if you see it, you should report it. That's what the authorities are there for. I don't think you should be, hovering outside someone's window to try and find it, but definitely just like anything else, vandalism, damaging someone else's property, trespassing. I mean, those are things, yes, that's what the authorities are there for, and you should at least have a police report made.
Let's talk about food smells. And we also ran a little poll on food smells. I actually don't have the percentages here, but I do have which smells people found they got the most complaints about. So
not brownies, probably.
No, you're right. Everyone loves brownies. That's true, right? And we're actually that's gonna come up. We're gonna talk about what smells people like and don't like and how it affects the actions that associations take. But do you want to take a wild guess which was the biggest complaint?
Oh, I would think sometimes some types of ethnic food have very strong smells.
So fish and garlic smells was what I received back the most. Second was seafood. Third was curry.
Yeah.
And then curry popped back up again where people commented fish and curry. So let's not concentrate on curry right now. someone is cooking, it's making a smell that another resident finds offensive right now. Let's use the word offensive. Does the association need to be involved in that?
Offhand, I would say no. That's, we haven't said that they have any kind of disability or need any kind of accommodation. It's just something they don't like. And unfortunately, in communal living, or townhome living, condo living, those kinds of things just happen. So I have a hard and fast rule. I will say I don't heat up or cook any kind of food in the office that's seafood, just because I don't like the smell either.
So once we're back, we're about what is a nuisance and what is not a nuisance, and food smells are a tough one. A lot of my research has shown there's actually been a lot of discrimination claims, because a scenario would be is there's been someone cooking brownies for years. I'll use that as an example. And everyone on the floor loves it. Oh, Mary's cooking brownies. They smell delicious. She'll probably bring me some more later. Then a new neighbor moves in and they create a different kind of smell, right? And let's use curry as an example, because that did end up being in a lot of these discrimination suits. And the board all of a sudden takes action. But the people that are cooking with curry are saying, hey, wait a minute. Why are you picking on my smell while the brownie smell is okay? How does that work out for associations? And is it a concern?
Yeah, it's definitely a concern. I mean, one of the things I try and counsel my clients on is trying to be consistent and uniform. And if smell is an issue, then it's all smells. It's not just who gets to decide what's the good smell and what's the bad smell. Because in a scenario, you can very easily see where someone who's cooking maybe their ethnic foods that do have a stronger smell would feel discriminated against and would think it's because of their ethnicity. And if we're not doing anything about the brownie smell, yeah, I would be concerned with someone who steps in to try and do something about a different smell, whether or not they think it's pleasant or unpleasant. It really needs to be uniform across the board.
I also read that a lot of associations put in rules where they require fan vents to be checked annually. And the reason they do it is they want to encourage people to actually utilize their cooking fans. Is that something, can associations put in inspections and rules when they're not overly concerned about actually fan vents and whether or not they're working, but they want to make sure that they are working so people are encouraged to utilize them?
Yeah, sure. I think that's certainly reasonable. I mean, again, it goes back to what's in the governing documents and what authority does the association have to require something like that. But I mean, along those same lines, I've seen associations that put in their declarations a requirement for owners to check their hot water heaters because they've had so many that leak over time. So definitely, I think they can do that. Whether they do it in a rule or an amendment to their declaration is just going to be the difference.
I did get some comments, and one of them was, just to throw it out there, we're single family homes, and sometimes we get complaints that someone is barbecuing and the smoke is blowing over into the yard. So I'm going to take a wild guess that you're going to just say to let that one go.
Yeah, I'm gonna put that along the lines of I would let that one go. Again, I deal with the cigarette smoke a little bit differently because it can affect people that have asthma, but just because they don't like the smell of the food you're choosing to cook outside, that's going to be really hard for the association to do anything about.
So let's talk about body odors and perfumes. And there's actually more complaints related to perfumes than there is body odor. We did do a poll, and we did ask the audience at some point previous to this, have you ever had to deal with a body odor issue? And more managers said they've actually had to deal with an issue than not. Is body odor considered a nuisance in a common area of the building? I have body odor, or I could have over cologne or perfume. And I'm going to make the question a little more complicated in a second on you, Cynthia, but is that overall considered a nuisance?
I think it's certainly considered a nuisance by the person that's smelling it, but from the association perspective, I think that that's going to be a really hard argument to make in front of a judge that it's actually a nuisance for the community.
So once again, in my research, we have found there are lawsuits popping up where people are claim it's a disability. They suffer from allergies related to perfumes and body sprays. And there are associations putting in fragrance-free policies. So does that make a difference if someone claims they're getting in the elevator with an individual on a regular basis and it is causing a physical reaction?
Interesting. So again, I think it comes down to, and you're probably getting tired of this answer, but whether they have the authority to do something like that. Can they regulate what a person puts on their body or doesn't put on their body, for that matter? And can they really do anything about that? So certainly, sure, they can have a policy in place. Is it enforceable? Probably in North Carolina, you're going to have a hard time enforcing that unless there's maybe some requirement in the declaration. I'll say I've never seen something like that in a declaration and I would have a hard time arguing in front of a judge that something like that would be enforceable.
And originally, just so the audience knows, we were just talking about perfume, and I received back a lot of comments that said, there's a lot of guys that wear too much cologne. So I'm glad that people corrected me. It's not always perfume. There's many gentlemen out there who overdo it with the cologne. So another aspect of this is hoarding and unsanitary conditions. And once again, we did a poll, and we asked, have you ever been shocked by a hoarding situation when entering a unit? Cynthia, I'm going to put you on the spot again. What percentage of people do you think have been shocked?
Oh, a lot.
You're right.
Over 50.
I was surprised. 62% said that they have been shocked by a hoarding situation. Boy, what a tough industry that's going to be sometimes.
Yeah.
So we're going to talk about this. We're not going to do a whole topic on hoarding, but we're going to talk about it in regard to the smells that can be created from a hoarding situation. So first question, does an association have to get involved if there's that kind of odor coming from a unit?
Yes. So that's a great question. And I look at that one a little bit differently, simply because if it's suspected that there's some sort of hoarding going on that's causing such a smell that it emanates into either another townhome or unit, there's really some more application for the association in that kind of situation, simply because depending on what's in the unit, it can cause damage to common elements or another person's unit very easily. So that one, yes, I think that there's some sort of investigation that probably would need to happen. I have seen it numerous times in townhomes and condominiums where there is a bad hoarding situation and the association does have to get involved, and sometimes the local authorities have to get involved to clean out the property just because it is causing damage to the rest of the community.
You mentioned the local authorities. What steps could take place? Could an association utilize local authorities first before they inject themselves in a situation? Does that make sense sometimes?
Absolutely. I would definitely suggest that and have suggested that to my clients. Call the health department. I mean, they're there to help. I always rely on the authorities to get involved first, because I would rather them go into the unit than have my association clients try and enter someone else's property without permission. And they often will have the authority to do that, not needing the owner's permission.
Well, I think we covered a lot, Cynthia, so I don't think we left too much out, did we?
I don't think so. You put me on the spot quite a lot, but I liked it.
Thank you so much.
Thanks for having me.